Hello Year 12s and welcome to this video, which is the first of two videos on the rights of victims. In this video, we are looking at the rights of victims to give evidence using alternative arrangements. There are three things that you need to do while you're watching this video. First, take the very best Cornell notes that you can. Second, use the pause and rewind functions. Use the pause function if you need to stop this video to take notes. Use the rewind function if you need to go over any information contained in this video. And the third thing that you need to do is have your summary books open in front of you. As we go through this video, I will give you some guidance as to what to include in your summary books. When you've finished watching and taking notes on this video, make sure that you read the pages from the textbook referred to on this slide. And if you find any additional information from that reading that you think is useful, then supplement your Cornell notes with that additional information. Well, let's get started then. Here is the learning intention for this video and the next video. Make sure that you write this learning intention in your Cornell notes. The learning intention is that you should be able to explain the rights of victims, including 1. The right of victims to give evidence using alternative arrangements, 2. The right of victims to be informed about the proceedings, and 3. The right of victims to be informed about the likely release date of the offender. In this video, we will be looking at the first right, that is, the right of victims to give evidence using alternative arrangements. In the next video, we will be looking at the right of victims to be informed about the proceedings and the right of victims to be informed of the likely release date of the offender. What I'd like you to do now is to draw up a table in your summary books, like the table on this slide. You need to complete this table by including in the right-hand column a description of each of the rights that a victim has to give evidence using alternative arrangements. You'll be able to complete this table as you listen to the description of these arrangements that accompanies the following slide. Alternative arrangements are available to victims who are witnesses in proceedings for sexual or family violence offences. Where a victim is a witness in a case concerning a sexual or family violence offence, then there are a range of alternative arrangements that the victim can use to give evidence in that case. First, the victim as a witness may give evidence from a place other than the courtroom. In such a case, the victim will typically give evidence via closed-circuit television so that the people who are actually in the courtroom, that is the accused, together with the judge, jury and lawyers, can see and hear the victim giving evidence. Second, a victim who is a witness in a sexual or family violence offence case may give evidence from behind a screen so they can't see the accused. In other words, if the victim is in the courtroom giving evidence, then a screen may be put up so that the victim is not within the direct line of sight of the accused. Third, a victim who is a witness in a sexual or family violence offence case may have a support person beside them to provide emotional support. So, while the victim is in the witness box, they can be supported by a family member or a close friend. Fourth, in a sexual or family violence offence case, the judge may direct that only certain persons are entitled to be present in court when the victim, as the witness, is giving evidence. Put another way, the judge in a sexual or family violence offence case may exclude people from the courtroom when the victim is giving evidence. These people will typically include members of the public and reporters. The reason for this is that in a sexual or family violence offence case, the matters about which the victim, as the witness, is giving evidence will be very personal, particularly where the person who is alleged to have committed the offence is a close family member. Fifth, in proceedings for sexual or family violence offences, the judge may order the lawyers to be unrobed. That means the judges will just wear ordinary suits, for example, in court. They won't look so forbidding or intimidating in their robes and wigs. And finally, in proceedings for sexual or family violence offences, the judge may order the lawyers to be seated while questioning the victim as a witness. That is, the lawyers don't stand and ask questions to the witness. In particular, they don't stand during cross-examination. And again, this is intended to reduce the intimidatory effect that lawyers may have on the victim if they are standing while questioning the victim. This slide sets out the purposes of alternative arrangements. There are 4 purposes of alternative arrangements, and you need to be able to describe and explain each of them. The first purpose of alternative arrangements is to protect the victim from contact with the accused. Remember that the victim is a witness in the trial of an accused for a sexual offence or family violence offence. In these circumstances, you can imagine that the victim is going to be really intimidated if they come into direct contact with the accused, that is, with the person who has been accused of committing the sexual offence or family violence offence on them. And that's the reason, for example, that the victim may be kept in a separate room from the accused and may be able to give evidence from that separate room. The second purpose of alternative arrangements is to reduce the exposure of the victim to the formality of the courtroom. As we've said on a number of occasions, courtroom procedures are very unfamiliar to most people. In fact, it's probably only lawyers who are quite familiar with courtroom procedures. As a result, victims are likely to find courtroom procedures quite intimidating. There's a judge who sits up the front on a bench wearing a wig and a robe. There's a jury that's observing proceedings. And there will be at least 2 lawyers, the lawyers for the prosecution and the defence, probably also dressed in wigs and robes, who ask the victim questions. The third purpose of alternative arrangements is to avoid causing the victim more trauma. The victim has already gone through the trauma of the sexual or family violence offence. In the courtroom proceedings, the victim is being required to relive the offence when the victim gives evidence about the offence, and that runs the risk of causing more trauma to the victim. So alternative arrangements are designed to try and minimise the trauma that the victim goes through in giving evidence about the offences that have occurred. The fourth purpose of alternative arrangements is to assist the victim to give reliable evidence. If the victim feels intimidated because they are in the same room as the accused or because they can see the accused and the accused can see them, if the victim feels intimidated by the formality of the courtroom, or if the victim suffers from additional trauma as a result of giving evidence, then there is a risk that the evidence that the victim gives will not be reliable. This is not because the victim is deliberately lying, it's just that the victim is feeling intimidated or is traumatized. So an important purpose of alternative arrangements is to put the witness as far as possible at their ease, and therefore to increase the likelihood that the witness will give reliable evidence. This is critical because a verdict is more likely to be fair if it is based on reliable evidence. Well, that brings us to the end of this video. Remember that our learning intention for this video is that you should be able to explain the rights of victims, in particular the right of victims to give evidence using alternative arrangements. In the next video, we will look at the right of victims to be informed about the proceedings and the right of victims to be informed of the likely release date of the offender. There is just one more thing that you need to do, and that is to read the pages from the textbook referred to on the first slide. If you find any additional information from that reading that you think is useful, make sure that you supplement your Cornell notes with that additional information. Thank you for your attention.